With me now is Omar Qureshi, Head of Anti-Corruption and Partner at the international law firm CMS Cameron Mckenna. First of all, talking about the Bribery Act, is this of particular concern to manufacturers and other commercial organisations?
Well, the Bribery Act is a piece of legislation that is actually designed to make it possible for prosecutors to prosecute companies in particular that are engaged in bribery and corruption, in particular foreign bribery and corruption. So it applies not only to UK nationals, individuals, but also to any company that's carrying on business in the UK. Now, there's some debate about exactly what that phrase means, but essentially, yes, it's definitely a piece of legislation that the manufacturing sector and all other commercial organisations need to be aware of.
What are the main offences created under the Act and the penalties?
Well, the Act creates 4 offences. What it actually does is to, in part, consolidate previously existing legislation and common law offences of bribery, but also improve upon them and bring them up to speed with the modern world. So it creates 2 offences, what are called general offences, if you like, of bribing or being bribed. So it catches not only the person that is trying to bribe someone, but also the recipient of the bribe. And it doesn't only capture people who actually give a bribe or receive a bribe. Merely offering or requesting a bribe is sufficient in that context. Then there are 2 other specific offences that the Act creates. One is a discrete offence of bribing a foreign public official. And that particular offence was designed to enable the UK to show that it had fully complied with its obligations under the OECD's Convention on Combating Foreign Bribery of Public Officials. And it's quite a different test. And actually one of the more easy tests to fall foul of, to be guilty of a corruption offence. So that's why there's a particular concern about companies and individuals who have dealings with foreign public officials in connection with their business. And then the 4th and final offence, which is perhaps the one that has received the most press sort of comment and criticism, if you like, is a corporate offence where a company that fails to prevent bribery will be guilty of an offence.
So how common do you think bribery is in the manufacturing sector?
Well, it's a difficult question. Transparency International, one of the more well-known organisations that assesses corruption risk, has a thing called the Bribe Payers Index, and that assesses corruption on a sector basis, business sector basis. And based on their studies, the heavy manufacturing sector is considered to be one of the more sort of high-risk areas, if you like, for corruption, whereas the light manufacturing sector is actually considered to be relatively low level for corruption risk. But at a more general level, corruption is a significant problem around the world. They have another study which they call the Corruption Perceptions Index, and it ranks 178 countries around the world by reference to the likelihood of their public officials to request or require bribes in the context of business. And what it shows, if nothing else, is that nowhere is immune to corruption. Even the cleanest countries have some degree of perception that there is a corruption problem. But what it also shows is that more than half of the world, on their study at least, comes out as being high risk from a corruptions perspective. So it is a real problem.
So how should directors of companies protect themselves? I mean, presumably there's a whole grey area of things which are just conditions attached to deals which are not bribes.
Indeed. The Bribery Act itself doesn't contain many defences, if you like, to the offences under the Act, but there is one defence, and that's a defence specifically aimed at corporates. So corporates can protect themselves against the corporate offence by putting in place what's called in the Act adequate procedures, which are designed to prevent bribery occurring. And essentially what that means is that company boards ought to consider their business in all its sectors and focuses and countries of operation and the ways they do business in the different places that they do, and assess the risk that they face in all of those areas from a corruption perspective, and then design policies and procedures that are designed to meet those risks and minimise, so far as they can, taking a reasonable and proportionate approach, minimise the risk that bribery will occur.
What are the ramifications for companies who are trading internationally or who are being encouraged by the government to trade internationally?
Well, the ramifications in theory at least are no different, but in practice, because if you trade internationally you're facing different risks perhaps than if you're only trading at home, because as we've already discussed, different countries are exposed to different risk factors in respect of corruption. Depending on where you trade, you might find it more difficult to do business cleanly than if you're trading in the UK. Some countries have a slightly different approach to corruption. Some cultures are different. In some countries, it's almost expected that certain things have to happen for business to be done successfully. So corporates will face those additional risks if they operate in those more difficult environments. But nevertheless, they will still be expected to take those reasonable and proportionate steps to try and prevent corruption occurring in connection with their business. And if they don't do that, and if it comes to light that business that they have conducted was won partly or fully through corrupt practices, then prosecutors will take a very dim approach, a very dim view of that, and will approach those companies accordingly.
Well, Omar Qureshi from CMS Cameron Mckenna, thank you very much.
Thank you.